You've been a regular on our show in the past. Welcome back.
Thank you, Brian. Glad to be back.
A lot of activity going on at the Patent Office since the last time you've been on, and love the opportunity to hear about it.
Well, Brian, there's tremendous amount of information going out from the PTO, and what Janet talked about in the American Invents Act was just the beginning of it. The micro-entity fee is a great opportunity for inventors to get a discount on their filing fees. But a lot of questions have come up is, what is the difference between what we had as the law, that was the first to invent, to now the first inventor to file? So what we have done is created 4 videos that cover the 4 sections of the law, the major changes from first to invent to first inventor to file. And as Janet mentioned, there is a microsite, and the videos actually reside on the very first page. There's a link to each one of the videos on the very first page of that microsite. So they're very easy to get to. We've cut them down to about 2.5 minutes each, and they go into a little bit of detail about the differences of what was or what is now the law compared to what it was before. And it's a lot different than it was in the past.
That's great.
So,
John, if you don't mind, could you take a moment just to explain to the listeners out there, because there has been questions that they're not sure what it means, and it's fantastic that you have these videos that they can reference all the time, which is on the uspto.gov website, the address that you gave. But can you just kind of tap into it a little bit so our listeners can understand?
Yeah, the new law is broken up into really 2 sections. One is dealing with what is the prior art that the examiner will apply against an invention, and that we call that the 102A section. And we have 2 videos that cover the 2 sections that are involved in the prior art. Then there are exceptions to the law, exceptions to the prior art, that are covered in what we call the 102B sections of the law. And so what we've done is we have 2 sections on the prior art, and we have 2 sections on the exceptions to the prior art. And what's interesting about this new law is there is actually an expansion, at least I think it's an expansion of what can be accepted from prior art. In past, an inventor, if they went to see a company and offered to sell a product to them, that basically started their clock ticking. That's a secret sale or a secret offer for sale, and that today is not against that inventor. So that secret sale or secret offer to sale is accepted from the prior art. Also, if someone derived or listened to somebody else talk about their invention and then filed on that person's invention, we call that a derivation of the invention, and that is accepted from the prior art. So there are safeguards for the inventor in the new laws, and I think that if individuals will go through each one of those sections, which we have on YouTube and on our website, that they can really understand the law a lot better than reading it. Because I can tell you, I've read it a number of times, and until I actually had to sit down and write what the law said, I really did not understand the full implications of the law.
Well, that's very good information, and it seems like just being involved with the inventors, John, it's almost a question where right before the deadline, people were panicking to try to save the few dollars before the fee went up. But now people are asking me, Brian, I need to file that patent right away because I have to race to the office and get it filed before somebody else gets it there before me. So when they ask me what I do, I tell them I keep doing the same thing, John. I have to make sure that I do my due diligence, I do my research, and when I'm ready to file for the patent, whether it's a provisional patent, non-provisional design, whatever it is, that's when I get it done. What's your take on that, John?
Brian, I think you're doing it exactly the right way. Now, you have to understand, we have had, and I did a lot of research on this before the bill was passed, and in about 7 years, there were about 500 situations where two inventors filed the same invention. Now, that went through the Patent Office in interference. We call that where, we're trying to figure out who actually gets the patent between the two inventors. In that same 7-year period of time, there were somewhere almost 3 million patent applications filed. So you're looking at a very, very small percentage, or a very minuscule situation where an inventor or two inventors would actually file on the same invention. I think that just says that, some people are going to have the same idea, and it may get close, at times, but take your time, be careful, don't divulge, keep good, solid notes, and we've always talked about having a good inventor's notebook, and I think that inventor's notebook is more important than ever because it will really prove that you did invent what you're claiming. Sure. If there ever was a situation where there were two inventions that were filed and you're trying to prove that that other person derived the invention from you, that really is important. So, again, due diligence, file when you're ready, and don't divulge before you file. I think that's the real important thing, that keeping it quiet, keeping it private is the most important thing we can think of.
And if you do have to divulge it, John, really, you want to make sure that it is something that is going to be patentable. Maybe you're going to make a prototype that works like you want it to work and feel the way it should feel. And during that process, you're going to have to speak to some people to get it to the point before you know what you might be filing. So when you're saying don't divulge, but at the same time take solid information down and keep that notebook, non-disclosure agreement, confidentiality agreements, those are acceptable as part of your notebook if you do have to divulge.
Absolutely, and those are very important. You still want to keep those disclosure agreements, those confidentiality agreements in force, so that you're really not making this a public disclosure. It's a private disclosure at that point in time.
Okay, that's great information. Thank you, John. I know there's a lot more activity going on by you. I just have to say what's really fun and interesting is my inventors group on Long Island. There's one in Suffolk County that I'm part of, and we just went to the Smithtown Public Library, which is now a research center. And I noticed that there's some other research centers around in the country also that inventors can actually go there and work on doing a patent search with some assistance from your office.
That's right, Brian. We have a number of patent and trademark resource centers around the country. These used to be called patent and trademark depository libraries, but they've become more than just the depository libraries. Those libraries now have librarians that are trained specifically to help inventors, help small businesses understand the patent system, help them do research, teach them how to do searching, really give them a hands-on assistance in moving forward in their invention and moving forward in getting their patent application into the patent office. It's more than just a name change. It really is more than that. It's now an opportunity for inventors to react or interact with somebody that's been trained at the U.S. Patent and Trademark Office. In fact, not next week, but the following week, we have I can't remember which number it is, but there is an annual Patent and Trademark Resource Center librarian training session, and that is happening the week of April 15th at the USPTO. And what happens is a number of these resource librarians come to the PTO, and they spend an entire week learning about what's happening in the PTO, learning about more options that they can use to help inventors around the country, learning about new resources that they can use, and so on and so forth. So they are really well trained and have an opportunity to get that information back out to the public at a free, it's free information.
It's fantastic. They're not going to give you opinions or marketing suggestions of your idea. They're simply there to help you and assist you through finding prior art and looking through the claims for you to take and make your own decision, or to bring it to a professional, somebody registered, possibly a patent attorney or patent agent.
That's exactly right, and that's what that's what their job is, to give you that leg up so you can do some of your research yourself.
Excellent. Keep the questions coming in. Brian at gotinvention.com. Email me. Hopefully we'll get to the questions towards the end of the show. John, by the way, with the patent libraries that are out there, what is the correct name for them? I'm sorry.
Patent and Trademark Resource Centers.
Resource centers.
Yeah.
You can find, if there's a resource center by your area, I'm sure it's on uspto.gov.
Yes, and all you have to do is, when you come into the home page, if you put, ETRC in the search window on the upper right-hand corner, it'll get you a listing, the mall.
Okay. Can you just give that one more time? I think you got stepped on there.
Yeah, it's again, search PTRC in the upper right-hand corner search window, and that will give you the listing of all the Patent and Trademark Resource Centers alphabetically by state.
Perfect. Thank you. All right. So, John, I know that there's other programs that have been started and are continuing to grow. Particularly, I'd like to speak about the Pro Bono program.
Yes, Brian. It's I spend a lot of time, almost every day, working on the Pro Bono program. And one of the things that happened out of the American Invents Act was Section 32. It's a very short paragraph, but it requires the USPTO to work with intellectual property law associations across the country, and it asks us to support and assist with the formation of pro bono programs that will help financially under-resourced independent inventors and small businesses. Now, currently, we have 4 programs that are up and running. The first one that was up and running was a pilot program, but it is a full-time program now, and that's in Minnesota. The second program that came online last summer, and that was in Colorado. In October of this past year, we had 2 additional programs come online, one in California and one in the Washington, D.C. metropolitan area. At the same time that the Washington, D.C. metropolitan area program came on board, we also launched the nationwide clearinghouse for entry into all pro bono programs. So that's what we call the first level screening, and we're looking for certain things within that person's information to make sure that they really do qualify for pro bono assistance.
Okay.
What happens after that first level screening, they are then forwarded to programs that are up and running, and some others that are what we call soft launch. They have not officially opened their doors yet, but are taking cases or taking applicants, and some of them have already been assigned to volunteer attorneys. A couple of those programs that are very close to opening are in Texas and in the Philadelphia region. We have others that are going to probably come on board in the New York City area sometime in the next few months. Again, also in Cleveland, Ohio, Pittsburgh, that area. We have programs in that we think are going to launch, supposed to launch sometime this year in Detroit, in Chicago, in North Carolina, in Georgia, in Florida, in Seattle, Washington, and also in Utah. So what our plans are is to have the entire country covered by mid-year next year.
Wow. I think when we first spoke, you were in Minnesota.
Right.
Wow. It sounds like there's some real activity and some real opportunity for inventors. just very quickly, because there's a couple questions coming in, and I have a few questions.
Okay.
I'm sure as the program is continuing to build, there's different things that are being changed and adjusted there. But do I have to be in one